Berardi Immigration Law is a great resource for the latest in immigration news and trends. Please be sure to subscribe to our channel. It really helps out the channel. And click that notification bell so you never miss a video from Berardi Immigration Law.
Hi, my name is Erica Chido, and I'm an attorney at Berardi Immigration Law. Today I want to talk about the marriage-based green card process, specifically the one-step process from within the United States. The marriage-based green card process is the process of obtaining lawful permanent resident status by virtue of marriage to a U.S. citizen. Typically, if the foreign national spouse is living abroad, the process will be multiple steps. However, if the foreign national spouse is living in the United States with valid underlying status, the process is a bit more streamlined. There are two main forms involved in this application: Form I-130, Petition for Alien Relative, and Form I-485, Application to Register Permanent Residence or Adjust Status. Form I-130 establishes the qualifying relationship that is the basis for the green card. In this case, that is marriage to a U.S. citizen. With this portion of the application, we include evidence of the bona fide marital relationship through a marriage certificate, proof of termination of any previous marriages, and documentation of your relationship. Form I-485 actually asks the government to produce the green card based off that qualifying relationship. In addition to these two main forms, there are a couple others that will be included in the application packet. First, Form I-765, Application for Employment Authorization. This form is used to apply for the foreign national spouse's interim employment authorization based on their pending adjustment of status application. Unless the foreign national spouse has underlying work authorization, they cannot work in the United States without this employment authorization. Second, Form I-131, Application for Travel Document. This is used to apply for the foreign national spouse's interim travel authorization, also known as advanced parole. And again, this is based on the pending application. Generally, the foreign national spouse cannot depart the United States after the application has been submitted without that advanced parole, or they risk having their application be considered abandoned. Third, Form I-864, Affidavit of Support. The U.S. government requires the U.S. citizen to establish he or she can financially support the individual they are sponsoring. Lastly, Form I-693, Report of Medical Examination and Vaccination Record. This form is used to establish that the foreign national spouse is not inadmissible to the United States on any public health grounds. The sealed medical exam must be completed and endorsed by an authorized civil surgeon. Because the foreign national spouse is lawfully present in the United States, the couple can submit all these forms together in one application package. Once an application is submitted, it is a matter of waiting for USCIS to process and adjudicate the application. Now, obviously, this is a general overview of the process, and circumstances vary from couple to couple, so I highly recommend calling Berardi Immigration Law to schedule a consultation and discuss your unique situation and whether this is a viable option for you.
Thanks for watching. Be sure to like our video, subscribe to our YouTube channel, and hit that notification button so you never miss one of these important updates. Also, check out the Berardi blog that's on our website at berardiimmigrationlaw.com. The blog is updated 2 to 3 times a week, contains tons of up-to-date information on policies and trends. You won't want to miss it.